So one of the most difficult things that you have to deal with as an investor, and quick proviso, Keystone Property Consulting Firm is to make sure that not only are our buyers and our sellers protected and staying above bar as far as the law is concerned and with their education, but our investors, right? Our buy, sell, invest strategies that we have here. It's critically important that you know the good, the bad, and the ugly. So when you make these decisions, you're absolutely doing it under the best levels of education. So one of the tripping points of being an investor traditionally means that you're going to have to be some type of landlord. And although this covers our commercial entity as well as our residential, we're going to focus more on the residential portion of it today because that's probably the most common. So let's talk about evictions. How you do evictions, notices, etc. Evicting a tenant is never going to be anyone's favorite task, and it's probably one of the most challenging aspects of having to be a landlord. However, eviction is typically necessary to protect your property and avoid more legal headaches and costly headaches at that, whether it has to do with unpaid rent or property damages. Knowing how to evict a tenant is going to involve an intricate understanding of the eviction laws, the processes, how eviction works, and the tips that you're going to need to safeguard yourself from bad tenants and scams. So, first off, we're going to focus on Florida, but learning your state landlord tenant laws related to tenant eviction is critical. An eviction is a legal process. This is how you legally remove a tenant from your rental property. And since landlord tenant laws vary from state to state, landlords are required to follow all the local regulations before they evict a renter. Most states are all going to require a tenant to be given a termination notice of some type before following some type of eviction in a lawsuit proceeding. And if a landlord attempts to evict a tenant without a court order, a tenant might even have the opportunity to sue the landlord for damages. So please be careful. But let me give you some instances here. Landlords in New York have the authority to evict tenants for non-payment of rent. After any applicable grace period, the landlord can give the tenant a 14-day notice to pay. In contrast, landlords in California must provide the tenant with 3 days pay or quit notices before beginning proceedings to even evict. In Florida, if a tenant doesn't comply, a landlord has to notify a tenant in writing of any perceived non-compliance, except for failure to pay rent. And I'll be specific about that. First off, if the issue can be corrected, the tenant will have 7 days in which to make that correction. If the tenant is still not complied with those demands after 7 days, the landlord can begin the eviction process because of non-compliance. Secondly, if the issue is one in which the tenant should not be given an opportunity to correct, meaning destruction of property, damage to property, intentional misuse, or continued unreasonable disturbances while being a tenant of the property, the tenant will only have 7 days to surrender the premises. No additional procedures need to take place. But each eviction case in Florida is unique, so be sure to obtain legal advice. We have some great lawyers that we partner with here at Keystone. We've got some great lawyers that we can advise you to go and talk to. But when you're dealing with real estate issues, you should be working with a real estate lawyer. A landlord, for example, cannot and absolutely should not evict solely in retaliation for a tenant complaining or to complaints that have been filed with a government agency about a code violation, for example, or asserting their tenant rights. That's why they have tenant rights. And as landlords, you're not allowed to just file a bunch of eviction paperwork because they're protecting themselves or leveraging the law to an annoying level as you as an owner. Um, Again, in Florida, focus non-payment of rent. Landlord must serve the tenant a written notice for non-payment of rent, allowing 3 days, excluding weekends and legal holidays, for the payment of the rent or vacation of the premises, meaning vacate, leaving the premises. If the tenant doesn't pay the rent or vacate, then the landlord can begin legal action to evict. For the landlord to gain payment of rent or possession of the dwelling, they must first file suit in the county court, the county where the property is listed, not their address, not necessarily a forwarding address of a tenant, but where the property, the dwelling itself exists, is where the court suit must be filed. The clerk of that county will then send the tenant notification by summons. If the tenant meets the requirements outlined in the summons within that time frame cited, or they fail to meet those requirements, it could result in a judgment and then ultimately entered. The clerk of the county court will issue a writ of possession to the sheriff, who will notify you that the eviction will take place within 24 hours after all of that stuff is done. Now, that's just non-compliance on the tenant side. Please know, to my investor friends out there, note that you have a lot of responsibilities too. I'm not going to dive too deep into the things that you need to be doing, but before you became an investor, you needed to have taken our investor class so that you know what you're getting into and you know what things that you need to be doing to make sure you are following those tenant laws to the fullest extent of the Florida requirement. So, learning your state landlord tenant laws is number one. It is the most important thing that you need to make sure that you stick to, and you need to make sure that you're following everything to the letter of that law. Step number two, you need to refer to your lease agreements and decide on the grounds for the eviction. In other words, you've got to actually have a valid reason to evict a tenant. It can't be because it's a Saturday and the planets are aligning and I just feel like being that landlord. Please review your tenants' signed rental lease agreements. Look for violations within that. Typical common grounds for evictions are obviously failure to pay rent. Consistent late payments of rent can also be just cause. Staying after the lease has expired, property damage, disruption of other tenants, using the property for illegal activity in that county, subletting without authorization, the units being taken off the market, for example. Owner move in can be a reason that you need to evict a tenant. And I mean owner, meaning you as the owner of the property need to take possession and move into the property, is still grounds for an eviction. And refusing to pay the legal rent increase as long as you've given sufficient notices for that. You need to document any of these types of violations thoroughly. The evidence is essential if the case ever goes to court. Those records are going to include images of any kind of damages, printouts of any kind of emails, text messages. Please be careful. They are not admissible as grounds, but they are kind of supporting. But they can't be the sole evidentiary that you're using to evict someone. You can't do it. That's not what text messages are designed for. Bank statements, return checks, evidence of these things. Without the evidence to prove out the case, it is going to be very complicated and will definitively delay the eviction intent that you're filing for. Some of the reasons you cannot ask a renter to vacate the property. Discrimination, absolutely not allowed. You cannot utilize or leverage race, religion, familial status, disability, or otherwise to discriminate against someone living in your property any further. Retaliatory evictions in response to a tenant complaint or a tenant lawsuit, absolutely not allowed. Withholding of payment of rent until a health or a safety problem is resolved. If they've shown you definitive proof that there is a health or safety problem, you need to resolve it as long as it is a mandatory resolution requirement inside of your county, and you need to do it timely. And then, of course, eviction of protected tenants or classes. You can never put yourself or your property in a situation that you're making decisions to vacate a tenant for the wrong reasons. You simply don't like them or don't like something about them. It's honestly that simple. You need to be careful. If you wonder if you're crossing any of those lines, and yes, sometimes this is a generational thing. If you're an older generation or a much younger generation, a person that's renting your property, and that is causing a disparity in the channels of thought that you have between how you think things should go and how they think things should go, I suggest you get either an attorney or real estate involved as a mediator to try to figure out whether or not both of you can get along. If you can't, maybe come to some kind of agreement on how you're going to handle the situation outside of going to the courts. If it gets beyond that and you need to go to some type of mediation, certainly here in Florida, we utilize mediation and arbitration groups all the time. It's a lot less expensive and a lot less time consuming than going through traditional lawyers and court systems, but it still may end up driving you to that ultimate courtside option. Next, speaking to and reasoning with tenants, which is what this drives to, right? Before you send an eviction notice, try to be the best citizen possible. Contact your tenants, discuss the current circumstance, and inform the tenant politely. This is a business, and you still need the reputation of being a good landlord, and you don't know what their story is. You need to be informative and to the point. Inform the tenant that the eviction process will be costly and it can harm credit. It can push you as far as wage garnishment for past rents that are due. It'll bring both of your names into small claims court. By doing this, they may be willing to vacate on their own without any contest. Or at least, and ultimately what you would want is for them to get the rent caught up and resolve the issue without any further struggles. But if you can't have the basic communication or you haven't set up the basic communications necessary to have a relationship with this tenant, then you probably shouldn't have been in a landlord business to begin with. It's perfectly okay if you have an investment property without it being a tenant hold. However, if your tenants refuse to comply and you want the fastest way to evict somebody without going through a long eviction process, you should probably consider offering them essentially cash for keys. It's an agreement entered into voluntarily by a landlord and a tenant to exchange a set amount of keys to a certain occupational property. So if your tenant agrees, you can create a lease termination agreement. They will sign it and date it, ensure that they have fulfilled their obligation under the contract, and then inspect the unit before handing over essentially a payment to help them get out without much more headache on your part. Ultimately, please understand, it's at the bottom line, it's about the bottom line. If it is less expensive for you to help the tenant with a cash advancement for them to vacate the property under the terms and the conditions that you both set and agree to, versus paying an attorney and then paying the judge and then paying the county to get all of that stuff, and potentially, paying a servant of the courts to go out and serve paperwork, it gets incredibly costly. And the longer that you're not getting rent for the property, if it's a cash turning property, and the longer that property is held up from a new tenant, do the math, right? Make the right decision. Step 4. If the eviction of tenants is going to involve more legal risk, and please proceed with caution, but tenants have rights and they have protections that, if violated by you or any representative acting on your behalf, it could absolutely result in a serious lawsuit. You need to know how to legally evict a tenant, especially in very important and complex cases. When the tenant has a lawyer, and when they file for bankruptcy, if they're a member of a state-sponsored housing program, or if it's your employee, for example, you are going to need an attorney's help. No questions asked. You need to have an experienced landlord eviction attorney on your side, and it will ensure that all of your actions stay within the legal boundaries. In addition, that attorney is going to be able to assist you and simply execute the eviction process, preventing the recurrence of similar situations for you in the future, and mediate talks with your tenants. So, the next step would be giving a written notice with cause included, right? The next step is going to make sure that you actually send an eviction notice. This is a formal request for the tenant to vacate the rental property. Most eviction notices, like the pay or quit notice, for example, is publicly available to you, and it allows the tenant to resolve the situation by paying any overdue rents or stopping the lease violation. Otherwise, they're going to be subject to a formal eviction lawsuit. And this is a difficult situation for a tenant as much as it is for a landlord. Don't let the passion of the moment and the heightened senses that are going to happen on both sides of the table, yours included, cloud your judgment and your ability to speak professionally and respectfully to each other. When the time on an eviction notice is going to expire, and it's typically within 3 to 30 days, depending on your state and the type of eviction notice it is, then you can file a formal eviction notice in a housing court. When you win the eviction case itself, most states will give the tenant up to about 10 days to formally move out and leave the property in good condition. If the tenant refuses to leave, a sheriff will be removing them and storing their belongings at expense. 3 types of eviction notices that you can use. You can download these on the internet. Make sure you pull the ones from the applicable jurisdiction of the house address that you're using that's up for problem. Before you use a document, please check with your local and state regulations again and again. Ensure you're complying with the law on how to evict the tenant most quickly. And that includes calling your local courthouse and speaking to the clerk of court's office. Validate what they tell you. Not everybody that picks up the phone at the clerk of court's office is going to give you the most up-to-date and the smartest solution for you to follow. Consult with an attorney and make sure what you heard from the courthouse is what you're going to be executing against. So, first is called the pay or quit notice. Landlords use this eviction notice when a tenant fails to essentially pay the rent. If it states that the rent is past due, gives the tenant a set amount of time, usually 3 to 5 days in most states. Pay this rent in due, in full, including any late fees. Make sure it's all documented out properly and line itemed as to what these things are. If your tenant pays the rent, you can avoid the eviction process entirely. Tenants in some states only have this option one time, meaning that if they ever run late again, in the future, you can just evict them for non-payment, even if they pay the past due rent. Second is called a cure or quit notice. Landlords use the cure or quit notice whenever a tenant violates a lease or a rental agreement under a condition, like having a pet in a building with no pet policy, hosting frequent loud parties where tenants are not permitted to host parties on the premises. Given a few days after receiving an eviction notice like this, they need to cure or correct the violation. If the tenant does not comply, they must vacate the property or face traditional eviction proceedings. And then the third is called the unconditional quit notice. Landlords use this one when the tenant has repeatedly violated the terms of a lease or failed to pay rent on time or on multiple occasions or multiple infractions. Landlords will use this one as a last resort if a tenant is committing crime on the premises, creating a public nuisance, causing severe damage to the property. And in this case, the tenant is going to not only be required to pay rent and resolve issues, but they got to leave the premises within a very specific time frame, usually 30 days, depending on the state, from the time it is noticed. Next step, you're going to have to prepare your documents, get all of your evidence together, and attend a court hearing. Since landlords are prohibited from taking matters into their own hands, they cannot physically remove an unpaying tenant from a property. Your only resort is going to be to file an eviction with the local housing court. Your attorney is going to handle all of the necessary paperwork, oversee the process, and defend you in court if the eviction goes to trial. If you represent yourself, there are items that you had better have with you and bring with you to the housing court. You must have a copy of the signed original lease agreement, records of payment like the rent roll and or the bank statements, copies of the correspondence with the tenant. Yes, probably printed screenshots of any difficult text messaging too. But again, text messaging is a supporting set of evidence to prove intent or context, but cannot be used as your only form of evidence. Evidence of the tenant's violation, photographs of the excessive property damage, if that's the case, witness testimonies that the tenant has been causing these problems with other occupants or with a community. Copy of the eviction notice and proof of the delivery. You either paid a court servant to serve it and they will give you a service notice, or you've gotten a signed letter that was sent directly to their address. And then, of course, you probably better bring at least one credible witness who can attest and testify to the tenant's lease or the law violations. Could be another building tenant, a superintendent, property management firm, potentially, contractor, repair person, whatever. Somebody went in to do repairs on your property and saw that the place is in shambles and all they're doing is fixing an ice maker. It's important for them to document that in their invoice to you. Moreover, once you get to this point and you have filed an eviction, you're going to be assigned a court date in which your case will be heard. The court date's usually granted within 30 to 45 days of you actually filing the paperwork with the courthouse. Could take longer if there's a backlog or if you're during the holiday season. Meanwhile, if you don't have an attorney, you probably better attend a few of those eviction proceedings at the courthouse to learn how the process works. Kind of show and tell scenario. Sit in, audit the courtroom, see how these things are, see what the questions are that are traditionally asked. Unless the judge hears your case early, you can expect to spend the entire day in court while you're in line. You cannot choose where the court assigns your case on the docket, so make sure you plan accordingly. The next step in this whole process is the actual eviction of the tenant themselves. If the court rules in your favor, you may have to still go to mediation to reach an agreement, or if the judge rules in the favor of the tenant and they owe unpaid rent, the judge will issue an order giving the tenant time to pay the overdue rent or face a new eviction notice. If the judge typically rules in your favor, the tenant should vacate your rental unit within a week or two. If the tenant doesn't leave voluntarily within that 7 to 10 day period, you're going to have to serve a notice to vacate through the sheriff's office. That notice will usually give the tenant 48 to 72 hours to leave, or law enforcement will forcibly remove them. Sheriff will not move the tenant's belongings, but will ensure that they vacate the premises. Then you can change the door locks, reclaim your property, pack up the tenant's property, do not dispose of it. You must legally store that information for store that property for a certain amount of time, and you can certainly add up the rental of what a rental unit costs for you to store their property. But that way you can get their items out, your property back up to a rentable status, and continue from there. All this should be considered a process of last resort. Communication is critical. Face-to-face communication is great. Please don't do these things alone. Make sure you always have at least a witness with you when you have them. Your real estate agent is a great witness to have with you. Your property manager, the same. Great witness to have with you while you're having discussions. They are not to take over the conversations. They are to be there to support the feelings and to keep things from getting heightened. There are some tips that you can use to protect yourself against bad tenants. because the eviction process can cost a lot of time, money, stress. Take some precautions and avoid a bunch of tenant scams, essentially evading bad tenants altogether. You cannot always guarantee that you have a good tenant, and there are some things you can do to help prevent these things. So start with learning, again, your state rental laws, perform background and credit screens. Make sure you know who the person is that you're allowing to move into your property. There are some tips that you can use that we utilize here at Keystone to allow you to protect yourself from bad renters and tenant scams. First off, again, you must learn the state guidelines. Every single state has different laws regarding property rentals. So ensure you're familiar with yours, understand your state's Fair Housing Act and landlord tenant laws. This will help you guard against tenant scamming and treat your tenants correctly. You, as a landlord, have expectations for this agreement between the landlord tenant as well. Next, keep very consistent records and documentation. You need to make sure and track your tenant records, including all communications, rent receipts, etc. These records should include tenant's name, contact information, property address, date of receipt, payment period, and amount. These records will help you keep detailed, manageable rent rolls, and you'll need them for taxes at the end of the year too, and they'll be able to assist you whenever conflicts occur. Property condition. You need to be willing to, and with the agreement of the tenant, able to inspect your property with them at the beginning and at the end of the lease and record any existing or new damages at both meetings. In addition, landlords need to be aware of the differences between normal wear and tear and damage to the property. Landlords need to use an apartment turnover checklist. They call them that because those are the first ones to be able to put it in place, and they're very effective. We personally use them. They have a ton of them out there in the public. It's easy to use. By utilizing this step, it's going to be really simple for you to protect yourself if a problem arises. They get that when they check into the unit. You check the boxes together of things that are an issue, and then when you're doing a clean statement, you're using essentially a new clean version of that same document saying, upon leaving, here's the condition of the property. You use those condition statements at the beginning and the end, and make sure that it's included in your lease with your tenant's signature so that you can leverage these for protection. Screening potential tenants before they move in. The screening processes that are out there are lots of softwares that do it. If you go through a tenant or a property management company, they typically also have their own systems that they put into place to make sure that you can access things like your tenant's credit, criminal history, eviction reports, validate proof of income, and their employment. You want to make sure to ask for references, ratings from current or past employers and landlords. It's a good rule of thumb that if people can't give stable references, and people that their boss at work can't vouch for them, where they lived before can't vouch for them, there's a reason. So you need to be aware of it. Quick 30 minutes today, but I do have some questions that are popping up in the window, so I want to bounce through these as well. And thank you for these, guys. This keeps the whole thing very interactive and make sure that everybody understands how this works. All you have to do is post your question inside there. It pops up to me on the window so that I can have some time to respond. Try to keep your questions relevant to the session that we're having today. Or you can reach out to us directly if you have questions from our real estate background. First one was, can I remove a tenant simply by calling the police? No. Landlords cannot ask a police officer to evict a tenant on their behalf. Sorry. Landlords have to go through the process. The police department is there to fortify and to enforce the laws. Until a law has been broken and they have some type of documentation from the courts to agree that a law has been broken, They cannot get involved. Now, things get violent, or if you're seeing excessive damage to a home outside where they can see intent, then they can certainly get involved, but it'll still be from an advisory perspective. And they would be able to tell them if this goes to court, things could get much more complicated. Landlords can request assistance from law enforcement under those conditions, and they can get further assistance approval from the courts if it looks like it's going to be a difficult eviction. So the police officer can be there with you on eviction day to validate that the tenant has left while the locks are changed, so that they'll document. So God forbid something else happens and somebody breaks into the home, they won't have to make any assumptions that that person had a key. Can you tell us again, how long does it take to evict a tenant? Again, depending on the state and potential court delays, evicting a tenant would take anywhere from 1 to 3 months. Process can take longer if the tenant refuses to leave or if they contest the eviction. Um, Make sure you're reading and complying with your state's landlord tenant laws to avoid those complications. And remember, if you're following our investment model, you only have 2 out of 12 months that you can have your property vacant and it still stay in the black as far as numbers are concerned. So be very careful and understand that if you keep allowing bad tenants to get in there, it's certainly going to affect your ROI on the property. Good question. How much does it cost to evict a tenant? Oh, that is a good question. Evicting a tenant, I have seen cost anywhere from $50 to $500, and can be more depending on your state laws. A typical eviction will cost the court fees, the attorney expense if they have to get involved, property damage fees, and the lost rent. All of that needs to be compiled in your rent roll for what this property's overall cost to your investment strategy is. So good questions today. Thank you so much. Look, almost every landlord is going to deal with some type of problematic tenant at some point or another in their career as a landlord and an investor. Certainly why you need to understand the law and understand the process of a tenant eviction from a rental property. You need to ensure that you are always following the legal and the proper eviction steps so that you do not get into a bind. How you go about starting the process in your county and in your area, the best point of reference is going to be calling your clerk of court's office. They'll be able to walk you through the proceedings. They may even have access to all of the letters and things that they have found to be the most successful in their local courthouse, giving you quite the leg up on the legal strategies. Thanks everybody very much. I realize this is a complicated topic. Certainly something that's on the minds. We're hearing more and more of it as people's budgets are getting squeezed and incomes aren't following suit. So be careful out there, make good decisions, and understand that the real estate market is still one of the best places to strategize and invest your money in the United States. It is a great and a secure method to do your generational wealth planning and to make sure that you have something for you and your family to enjoy as an income strategy for years to come. Thank you all very much for your time. Have a great day. God bless, and enjoy your weekend.